Hi everyone, and welcome back to PA's The Break video series. My name is Clare Irvine. I'm the Government Affairs Counsel for PA Northeast, and joining me today is Brad Lachut to discuss the liability of reopening now that businesses are allowed to start resuming normal operations. At least those days are coming. So with that said, I'll turn it over to Brad.
Thank you very much, Claire. Claire said, I'm Brad Lachut. I'm the Director of Government Affairs for PA Northeast. And today we're going to be talking about the liability of reopening a business. We have been getting an increasing number of questions on this from our members, curious as to how their clients, as they move to reopen, how they can do it safely and what the insurance repercussions are of opening if some customer was to claim they contracted COVID while at a particular business. So I figured this would be a good topic to go through now and hopefully answer some questions and ease some concerns. So first we'll do a brief overview of what we're talking about. First, the liability of reopening. What are we talking about? Dive into the commercial general liability policy, because that's really going to be the policy that's going to be at issue here. Talk about the exclusions. Talk about the occurrence, or what an occurrence is, and we'll get into that, don't worry. The covered property and the defense costs. And I put the there a lot. There's this band called Manchester Orchestra. I'm not sure if anybody knows it. They released an album a couple of years ago where they had every title, or the title of every track started with a the. I really liked it for some reason. So I'm like, I'm going to do that too. So that's why there's a the here, for no apparent reason other than to amuse myself, which really is why we're all here anyways. So first, let's get into the liability of reopening, right? As I mentioned, there's increasing concerns in the business community about what the liability of reopening is. Everybody wants to reopen, but I don't know if people want to open their doors only to get a flood of lawsuits the next day and have to close their doors. So there is some concern as to what's going to happen. Will a business be liable if a customer claims they contracted COVID-19 while at the business? Perhaps, probably just as important, will there be coverage if in the event that somebody does claim this? So I figured let's dig into that right now. First, with the commercial liability policy, the CGL. In order for there to be coverage, or for the policy to come into effect, to be triggered, there's got to be a couple things that this is a little bit of insurance 101, but it's worth going over, right? In order for there to be coverage, there's got to be an occurrence that results in a covered loss, or a loss that is covered. So first thing, covered loss. Second, loss stems from an occurrence that resulted in bodily injury or property damage on the covered premises. In layman's terms, that means that there is coverage for an injury or property damage that was caused accidentally and occurred on the insured property. So the first question really to look at is the covered loss aspect. Is contracting a virus a covered loss? The general rule in insurance is that a policy covers any loss. It does not specifically exclude. So really, in order to answer this question, we need to look at the common exclusions to see if there would be coverage or not. So with that, let's turn it over to the exclusions. There are two common exclusions in policies that you're likely to see. The first is the mold exclusion. Now this exclusion excludes coverage for exposure to fungi or bacteria. However, viruses are not mentioned in the mold exclusion. So a bodily injury as a result of a virus would be a covered loss if there's no other pertinent exclusion. So if you're only dealing with the mold exclusion, likely there would be coverage for a virus. And I should say it's pretty well accepted that a virus causes bodily injury. So I'm not going to get into that aspect of this at all. I'm just going to assume that a bodily injury did occur. So speaking of pertinent exclusions, another one that comes into play here would be the communicable diseases exclusion. As you might expect, this sort of exclusion does include viruses. So if this exclusion is in place in a CGL policy, there's likely not going to be coverage in place for a COVID claim. So the key for any producer is to look at the policies, see if there's a mold exclusion. If there is, I guess you're happy because viruses aren't included in there, right? But then look to see if there's communicable disease exclusion. If there is, then we're going to have trouble finding coverage here. However, as we're going to talk about in a few minutes, it might not matter. So next thing to look at here is the occurrence, whether the loss was the result of an occurrence. Now, an occurrence is defined as generally speaking. An accident which would include continuous or repeated exposure to substantially the same general harmful conditions. So in the case that we're talking about right now, exposure to COVID or repeated exposure to COVID. Now the question is that an accident? I honestly don't know. Honestly, I don't think anybody knows for sure, really. The issue of what an accident is has been litigated for hundreds of years and has financed a lot of second homes for attorneys in Florida, right? It's this thing that you can really go back to English common law, and this is something that gets debated of what an accident is. So it's very difficult to determine what an accident, which leads to a lot of ambiguity here and a lot of questions, right? Some courts have held that contracting a disease can be an accident. Others have found that it's not. In my research, what I've discovered, though, the courts that have found that contracting a disease is considered an accident, it's really got to be kind of an obvious one. One of the weirder ones I read about was about an apartment complex where a person contracted a disease because they were surrounded by chicken feces. I have no idea why there's chicken feces in this apartment building, and the court generally agreed and said, yeah, this doesn't seem right. Clearly an accident, this should be covered. So outside of that, I'm not sure. I wouldn't hang my hat on a virus, contracting a virus being considered an accident, especially when, in the case of COVID, when it's so widespread. There's also could be an aspect of assumption of risk going out. You're knowing that the COVID virus is out there and very widespread. You're assuming the risk that you might contract it by even leaving your house. Anyways, I think what the really important question, though, here is, and what you're going to see a lot of claims be thrown out or liability not be extended, is whether the loss occurred on the covered the covered property. So, in other words, can it be proven that the virus contracted at a particular business? And again, I think this is where a lot of the potential claims are going to collapse. Good luck proving that you contracted an illness from a business. The standard for demonstrating that you contracted a virus in a particular business or a particular spot is near impossible for employees at the best of times, let alone customers in the situation that we're dealing with now. As I mentioned, because COVID is so widespread, you can easily make a claim that you didn't contract it at a business, but you contracted it walking down the street or going to the grocery store or getting in your car or something like that, right? It's just very difficult to prove that a loss occurred at a covered property. And again, I think that is going to be the issue here, where claims are going to get thrown out because you can't tie it to a particular business. Now, there could be instances of gross negligence, where a business is not adhering to social distancing and not providing face masks, things like that, which might make a finding that the illness was contracted or the virus was contracted in a business more likely. But again, I don't see it as being a big issue. Now, this also leaves one outstanding issue, though, assuming that liability won't extend, and that's the issue of defense costs. So it's likely that businesses will not be liable for customers who claim they contracted COVID-19. But there's also the question of defense costs, which can get pretty high. So the duty to defend determination, that is the duty of an insurance company to come in and defend a policyholder, does not take merits of the claim into consideration. Well, it's very difficult to show bodily injury was caused by an occurrence on the covered property, which we just mentioned. Proving that it didn't may not be possible in the complaint stage. So you're likely to see defense being provided by the insurance company because the complaint is going to be worded in a way to trigger coverage or potentially trigger coverage. Even if the virus exclusion was in place in a policy, I would expect plaintiffs' attorneys around the country right now are thinking of creative ways to rope in insurance policies. So I'm thinking the end result here is going to be that there's unlikely to be coverage in place, either because there's an exclusion or more likely because there's no liability because you can't prove that a virus was contracted on a particular premises. But it will be likely that insurers will be required to provide defense costs. So at the end of the day, defense costs will be provided by the insurance company and probably no successful claim on the part of the business. They shouldn't have to pay anything out because, again, the difficulty of proving that a virus did occur, which I've said, and I think now 20 times. So I think that's what it is right there. A very scary situation, a pretty big deal, but I think at the end of the day, this shouldn't be a major concern of businesses right now. Again, as long as they're adhering to all the practices that they should be in government guidance in terms of how they should be reopening safely. So with that, I'll mention, of course, as always, the questions. If you have any questions on this or any other topic, you can please send an email to myself or Clare, the Resource Center. Clare, the Resource Center, ideally, not me, or you can give us a call. With that, I guess we'll open it up for discussion. Clare, you got anything for me?
I guess one thing is we've been hearing a lot about super spreaders, like where you have someone who, for reasons there's scientists are still trying to figure out, will spread the illness a lot quicker than other people. And we've seen this happen. It comes up in the news from like birthday parties or work conferences. Would having a super spreader on your property affect the liability at all?
Yeah, I guess that's a good question. So I guess if the super spreader was an employee, then I guess I'm guessing that would probably be the case. Then it's probably more likely than if that person didn't exist or wasn't an employee, that you could show some direct link between the business and contracting COVID. That the attorney can say, okay, this person has been demonstrated to be a super spreader, whatever that definition would be, or however you prove that, and then you could show that link. I again think it's pretty difficult because you have to then eliminate that person who contracted COVID did not encounter a different super spreader anywhere else. So I think it's still an uphill climb, although maybe the hill is slightly less steep because of that.
And what about for businesses as they're reopening? Do the steps that they're taking to try and reduce the likelihood people will get COVID-19, both for liability reasons and also generally caring about other people, would those impact their liability? Like if they're limiting the number of people in their store, continue to require face coverings, their cleaning procedures and other administrative controls, would those factor into the likelihood they're found liable?
Yeah, it's a great question. And I think absolutely, judges are people just like everybody else. So if they see a business that is just not following any of the guidance, just packing people in very unsafe conditions, they're more likely to allow a claim to proceed and perhaps find a link where maybe they wouldn't if the person was following the proper procedures. So following those procedures are important for exactly why you said. One, because it's just good to keep everybody safe, right? We don't want people to be in danger and getting sick. But from a liability aspect, the more you follow the rules and do the right things, the less likely liability is going to extend. The more negligent you are, that's why claims exist. It's almost the very reason that they exist, right? So yes, I would say absolutely following that guidance is very important to preventing illness for one, and two, to limiting a liability standpoint as well.
All right, and on that note, we'll come out with videos more on what steps you can take to mitigate the liability based on guidance from the different state health departments as well as the federal government. So keep an eye out for that video in the next couple days.
Great. Well, thank you everybody for joining us, and we'll see everybody soon.
Stay safe out there.
Or in there.